On my immediate right is Stewart Rhodes. Stewart Rhodes is a lawyer. He's practiced in Kalispell and Polson. Stewart served 3 years on active duty in the United States Army. One must question his good judgment because he was a guy who liked to jump out of perfectly good airplanes. And I want to thank you for serving, Stewart. Stewart, after he left the Army, having jumped out of one too many perfectly good airplanes, because he was injured in the course of the parachute jump, attended UNLV. He graduated from UNLV with highest honors. From there, he went on to Yale Law School, where he won a prize for one of his writings. Interestingly, Stewart is a sculptor. He's been a firearms instructor. He's been a self-defense instructor. Notably and currently, Stewart Rhodes is currently the president of the Oath Keepers. The Oath Keepers is an organization of soldiers, sailors, Marines, airmen, and law enforcement officers who are called upon to remember that the oath that they took when they entered the service, when they became officers, when they entered law enforcement. That is, the oath that at its heart says, we swear to protect and defend the Constitution. When I was, I'm also a veteran, when I was with the ACLU, some people would say, oh, you were in the Army and so on and so on, and why are you with the ACLU? And I said, I took an oath to protect and defend the Constitution, and I'm still carrying out that oath as the legal director of the ACLU. Next to him is Nikki Zapanik. Nikki is currently the public policy director of the American Civil Liberties Union of Montana, and you've been there for what, about 3-4 years now, yeah? She's a graduate of the University of Redlands in California, and McGeorge School of Law. She's served not as a legislator, but as a staff person in the California legislature, and was in private practice before she came and graced us with her expertise in Montana. And finally, my colleague Anthony Johnstone. Anthony's assistant professor of law at the University of Montana School of Law. He teaches constitutional law, and he's well equipped to teach constitutional law, having served as the Solicitor General for the state of Montana. The Solicitor General is the one who most of the time stands up in front of an appellate court and argues the issues. And so when we hire at the law school, we look for people with significant practice experience, and Anthony certainly has that. Anthony's a graduate of Yale University and of the University of Chicago Law School. So welcome them. We're going to do it this way. Each of the panelists is going to give a 3 to 5 minute presentation. I will kick off with a question to them, but we are not going to try to have this conversation take place and then stop and say, okay, now you may join. What I want you to do is join into the conversation as it's taking place. So after the first 3 presentations, the floor is open. I'll keep my eyes open. I'll point to you, and when we get a break, I'll say, okay, what's up? If we can sort of keep it on topic.
Yeah, Jeff is actually an Airborne Ranger veteran, so he's a fellow airborne soldier, so who would have that? I'm going to open up also by quoting something from Article 6. And right after the point where Jeff left off, it says, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So that is the oath requirement in the Constitution itself. And as Jeff alluded to earlier, part of keeping that oath doesn't involve just those in the military, obviously. It's everybody else, including us lawyers. And like Jeff, I feel the same obligation. Same reason why he served as an ACLU lawyer, and my hat's off to him for doing so. I've also gone out of my way in pro bono cases to defend the Constitution to the best of my ability under my oath. He alluded to also a change in, or a supposed change in the perception of the role of the 10th Amendment, I'd like to harken back to something written by James Madison, who is rightly considered to be the father of the Constitution. It was his Virginia plan that became the heart and soul of the Constitution at the 1787 Convention. This is something he wrote in 1798. And he talks about the duty of the state legislature. He says, "It is their duty to watch over and oppose every infraction of those principles of the Constitution which constitute the only basis of that union." And he says, in particular, in case of a deliberate, palpable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereto have the right and are in duty bound, not just a right but a duty, to interpose for arresting the progress of evil and for maintaining within their respective limits the authorities' rights and liberties appertaining to them. He wrote this in the Virginia Resolution of 1798. It doesn't sound like an enunciation of the supposed province of local government or state powers. It sounds much more like an obligation and a duty to defend the Constitution of the United States, and in particular, the Bill of Rights. Marine General Smedley Butler, the very famous winner of 2 Medal of Honors, once said, "There are only 2 things worth fighting for. 1, defense of your homes. 2, defense of the Bill of Rights. That's it." He said, everything else is a sham. War is a racket. But he was still firm on that. Now, what was Madison objecting to and discussing in the Virginia resolutions? It was the Alien and Sedition Acts. Almost immediately, with the ink on the Constitution hardly even dry, and the First Amendment, almost immediately, a law was passed in the name of national security during the quasi-war with France that criminalized speech. And you had newspaper editors and reporters being arrested and thrown in prison simply for criticizing the president or his policies. Now, this is a law passed by Congress, signed into law by President John Adams, one of our great founding fathers. And do you think the federal courts stopped this? In fact, I just learned from Jeff earlier that Chief Justice Chase directed juries that they must convict. So you had almost immediately a breakdown in the purpose of the Bill of Rights. The preamble of the Bill of Rights is not in your materials, unfortunately, but it says right there, to prevent misconstruction and abuse of these powers. That is what the Bill of Rights was for. But almost immediately you had all 3 branches of the federal government directly violating the First Amendment. What do you do when that happens? What is your recourse? Simply elections? The answer of Madison and Jefferson both was no. The states have a duty. The people themselves, as we said earlier, are sovereign. And it is in their states, they have a duty and an obligation to stand up and protect the people against such abuse. We are now in a direct parallel. The Patriot Act, and most recently the NDA of 2012, which contains direct provisions that allow military detention and trial of U.S. citizens, is our modern day Alien and Sedition Act. Every bit as violative of our rights as what they suffered back then and resisted against. What is our recourse now? They're passed with overwhelming majorities in Congress, a bipartisan assault on our Constitution and Bill of Rights. What do we do as people? The federal courts? Don't look to them to defend you. They will not. They have not yet. To the contrary, they've upheld it. In the Hamdi case, the most recent case in 2004, saying there's nothing in the U.S. Constitution that prevents the U.S. government from detaining one of its own citizens as an unlawful combatant. Directly flying in the face of Article 3, Section 2, it says trial in all cases must be by jury, and Article 3, Section 3, which says that treason shall consist only in living war against the United States or aiding and abetting its enemies, and no person shall be convicted of treason except upon 2 witnesses to the overt act or open confession in open court. So directly flying in the face of direct commands of the Constitution, they're saying we can go ahead and treat the rest of you, all Americans, the same as somebody in Iraq or Afghanistan, like a foreign enemy in wartime. What do we do in this circumstance? This is, to me, far more important a question than local rule in a county or a town or even in the state as far as drinking age, things like that. That certainly is important. And I think Nikki's going to talk maybe perhaps a little bit about medical marijuana. Another very good example here in Montana. The people of Montana decided they want to allow it, but what happened? The federal courts, the federal legislature have all said, we can do what we want to, despite your best wishes. We'll come in there and do it anyway. We'll criminalize. We'll wipe you out. You have Chris Lindsay, a Montana lawyer and provider, now facing 25 consecutive life sentences for something that was legal in Montana under Montana law, passed by resolution by the Montana people. So, what do we do?
Somewhat unprecedented that we are at a crisis stage, much as we were at the end of the 18th century. Nikki says several things, and I want to summarize those because actually they tend to parallel how I thought the conversation would go. One of the interesting things about state sovereignty is that states have the power to increase individual liberty through their constitutions, through legislation. Second thing is that notwithstanding the state's powers and abilities to increase individual liberty, the federal government has the power to restrict what the states can do. And there are some limitations on those restrictions, or on the ability to restrict. That is, that the federal government cannot commandeer state mechanisms to carry out its powers and to carry out its laws. The third thing she mentions is the idea of the carrot. And what I'm thinking about is the carrot with the strings attached, the doctrine that we refer to as conditional spending, the doctrine by which Congress says, we will give you this wonderful pot of money, and the state goes, oh good, because we need some roads, and Congress says, but. And there are a lot of things that have to do with the but. One of the things that has to do with the but is the rest of the language that are referred to with respect to adult rights. That is, the original provision in the Montana Constitution said that 18-year-olds have all the rights of adults, period. And it was because of conditional spending that the additional language with respect to drinking was added. And we'll go into that in a little bit of detail. Then Anthony, very interestingly, points out that with all of this going on, there's the opportunity for popular sovereignty confusion, if I can coin a phrase. That is, the idea that, well, we should look to our local officials to affect federal policy. We should look to federal officials to affect local policy. The second part is an interesting one because it arises out of the idea that someone or some group or some interest or point of view who wants to make changes within the 50 states with respect to social policy, for example, has a choice. They can succeed in some states and not in others, in which case maybe half a loaf is all they get. They can go to the expense of making 50 visits to 50 state legislatures, or they can do some one-stop shopping by going to Washington, D.C., in which case they get a federal policy that hopefully will affect all 50 states, that is overriding the interests and desires of the citizens of an individual state who might not like the policy, or simply doing it in an efficient manner. So with that sort of summary, I think I want to start out with two provisions, because it's useful to talk about real things when we're talking about theoretical concepts. One you're very familiar with, and that's the Medical Marijuana Act. The other one is the Montana Firearms Freedom Act. The Montana Firearms Freedom Act was an act, a proposal, not carried, but Gary Marvitt's idea that we should be able to manufacture firearms within the state have them identified as Montana firearms by a stamp on the weapon, and have them sold only within the state. That is, he's going, this is solely interstate activity. It's not interstate activity, it's not interstate commerce. And because it's solely interstate activity, and because we got a means to identify it as an interstate activity, and because I'm not going to sell my firearms to somebody right across the border in Idaho, I'm only going to sell it right here in Montana, no longer is Congress and the very popular Bureau of Alcohol, Tobacco, and Firearms in a position to tell me that I can't do this. So with those two things in mind, let's talk about those two provisions and how that plays into the Supremacy Clause, what sort of 10th Amendment arguments arise and how they tend to fall.
Well, this is kind of the problem with, I won't say a problem, but in rebuttal to Anthony, that idea that each one stays in their own bailiwick would be wonderful, but they don't. And medical marijuana is a really good example of that. Here you have, and this is falling right hot on the heels of the Raich case. Gonzalez versus Raich is a woman who was dying of cancer in California. She grew a medical marijuana plant in her own backyard for her own consumption, not for sale, not to be transported across state lines whatsoever. And under Lopez, she was fine. Because the Lopez court, in that case was a gun rights case. In that case, Scalia likes guns, so he voted with Thomas and said, you know, a majority, and said there has to be some kind of limitations on the commerce power. It can't just be wide open, otherwise it makes an absurdity. But in Raich, because he doesn't like pot, he voted along with the people on the court, most of them on the left, who liked commerce powers. And he said Congress can regulate this possession of a plant she grew on her own backyard because it somehow affects the market in marijuana, the illegal black market in marijuana. So they opened the door wide back open to Wicker, the case from 1942, which said that even a farmer growing his own wheat for his own personal consumption has an impact on commerce to be regulated. So now Congress can make any law it wants to about anything. And look what happened to the people here in Montana. Medical marijuana providers now facing years in federal prison. They'd have been fine under Lopez. They're not under Raich. And why? Because of the drug war. And so, once again, I'm not talking about having the legislature of the state stand up in all cases. I'm talking about, as Madison said, in case of deliberate, palpable, and dangerous exercise of other powers not granted by the said compact. The Commerce Clause has been turned into an absurdity. It was never intended that Congress had a plenary police power to make criminal laws about everything under the sun. The Bond case is a real good example of that absurdity. How could she possibly know she's in violation of some chemical warfare treaty that's been turned into a federal crime? So the medical marijuana case is a really good example. Of course, the Made in Montana gun bill is interesting too, but since Raich, what's the likelihood of that prevailing in the federal courts? If they can regulate the growing of a plant in your backyard for your own personal consumption, not for sale, what chances does a Montana gun manufacturer have?
Scalia likes guns.
Right. You have to overturn Raich. So we'll go back and forth on Scalia as the new linchpin of what the Constitution means.
I want to remind you, jump in here anytime. Yeah.
Now this is, because you sound like a very distinguished group of attorneys and professors and whatever else. I just took a case.
We are, yeah.
I just took a case to the United States Supreme Court. I actually saw Scalia argue on January 23rd on the Jones case, on the GPS tracking system.
Oh.
Now what I wonder is, I took a securities case against the state of Utah for two financial planners in the Broad case, and I argued 6 violations under the United States Constitution, 29 under the Utah Constitution. And the way I argued it is that through the 9th and 10th Amendment of the United States Constitution, because this was a 1983 civil rights case, that through incorporation, all those rights under the Utah Constitution would then be included in the 1983 civil rights provisions and protections. And the courts kept trying to separate those two. you know, but if you look structurally at the way the United States and our history is, you had the 13 states that then came together, so they all had their constitutions, like you're saying with Jefferson, already had the Virginia model done, and the United States patterned that, so they already had those and incorporated them, I think, through the 9th and 10th Amendment to preserve their rights, and then you've got all the states like Montana and Utah and Wyoming, all the western states.
And so how did that go?
Well, what we did is we went up to the 10th Circuit and we got half remanded back down to the district. And that's the part where we're struggling with is the state, the federal court's trying to argue, the district court is trying to argue they don't have jurisdiction over our state constitutional claims, and should we take it into the state? But we're arguing through the 9th and 10th Amendment, through incorporation, that those then become part of the 1983 civil rights suit, and a lot of the provisions are the same in the, you know, and I would say if all rights that are not expressly listed, you know, belong to the federal government, are reserved for the states and for the people in the 9th Amendment, all unenumerated rights are reserved for the people, that then pulls it into the federal level, keeps it in the federal district court, giving them jurisdiction in 1983 civil rights is a federal question.
So Justice Johnstone, how do you rule on that?
I haven't read the briefs. So the 9th and 10th Amendment are primarily, and I think it really ties together well, matches with the preamble of the Bill of Rights, which is very important. I encourage people to read it, why it was passed. The Constitution wouldn't have gone through without the Bill of Rights. But the 9th and 10th Amendments primarily are rules of construction of the rest of the Constitution. I think that's what makes Bond interesting, and you should probably take a look. I can see now why you're interested in that case, because it provides an individual cause of action, or standing for purposes of that. And, you know, I think, circling back to how these themes have come up in Montana, too, with the Montana Firearms Freedom Act and medical marijuana. You know, I sympathize with Stewart, but I think he proves my point. The federal government won in the Supreme Court in Raich.
Doesn't make it right.
Well, so people disagree about these things, but those disagreements in court will get you so far. And then it's up to we the people to act. The Constitution belongs to us, not to the Supreme Court. So, and again, you know, the Virginia resolutions were, and this goes to the Montana Firearms Freedom Act, wasn't Virginia and Kentucky that pardoned those convicted of seditious libel. It was President Jefferson. President Jefferson was elected by the people of the United States through all of the states in the Electoral College. I think this goes to, the Montana Firearms Freedom Act, what these acts can do, and actually the Montana Firearms Freedom Act is a great example because it migrated to other states and became the Healthcare Freedom Act, some of the basis of the suits against the Affordable Care Act. Unfortunately, most of the states found that they didn't have standing. The courts said that they didn't, but it did start an important discussion about the limits on federal power. Again, where that's going to have bite broadly, and I think we've seen it, is in the political process and the values that we, the people of the United States, have and what limits we want our federal government to respect. Through all of these things, again, people disagree with the government's limits on these things. Very few of those disagreements are going to be resolved, finally, in the courts. Those disagreements are generally broadly...
My name is Bob Fanning, and I'm running for governor. I had asked Stewart to be my run for attorney general, and there was another Rhodes by the name of Clinton, who is the lawyer that's bringing to Montana.
You both turn them down.
Don't turn me down. I got to change my cologne. But I had asked them both because they do stand for something I stand for, which is the breaking the flawed paradigm that the sovereign immunity clause trumps the 10th Amendment. We have to do something about that, and it has to, and dual sovereignty.
You mean supremacy clause?
The supremacy clause over the 10th. Did I say something else?
Yeah. Okay.
Sorry. So the supremacy clause it is, since 1972, when the Bretton Woods Agreement was broken by Mr. Nixon, we had a change in the whole economic sphere where the federal government was given unlimited resources with the printing press in order to buy policy. And now we have a unique opportunity in American history where the governor, in answer to what do we do, the governor has to take a leadership role and say that the 10th Amendment was not trumped or annulled in 1865, but instead the government can take the bully pulpit and bring the natural friction of leadership in defense of the people, in that natural friction to break the flawed paradigm of the Supremacy Clause and the Commerce Clause being the dictatorial powers that will hold us prisoner to these corporations as corporate fascism, because the Supreme Court does make errors. They did allow slavery. They do allow corporate fascism, and it is the governor's job to stand up and